The state finally gets a chance to cross-examine the alleged intruder of the Khumalo home. Hello and welcome to Inside the Courtroom, the Senzo Meyiwa murder trial wrap. I'm Linda Mnisi. It's an absolute pleasure being in your company this Sunday afternoon. We're coming to you live from our Randwick studios in Johannesburg. Remember to join in the conversation. As you know by now, we do have a poll question that we run every single Sundays. And today's question is, do you think Bongani Ntanzi's evidence is on the right track or lacks credibility? And the last one, you are not sure. Scan the QR code and start voting. But also remember, you can tweet us and, of course, get in touch with us via our social media platforms. That's Facebook and Twitter. Our handle is at Newzroom 405. But throughout the show, we do have open the lines rather for any calls, so you can get in touch with us to weigh in on the conversations. Those numbers are on your screen right now. You can also send us a WhatsApp message on 072-110-5584. You can also call us on 010-594-6010. We will make sure to read your messages live on the program, but also, of course, make sure that we take those calls. So get in touch with us and, of course, interact with us throughout the show. Let's get to it. Now, the state has largely focused its cross-examination on cell phone records of Bongani Ntanzi. That's accused number 2. A reminder that the state alleges that Ntanzi is the hoodie-wearing intruder who entered the Khumalo home along with the gunman to allegedly execute a hit, allegedly ordered by Meyiwa's then-girlfriend, that singer Kelly Khumalo. These are allegations that, of course, Bongani Ntanzi vehemently denies. Now, this week, the state started with, among others, the version previously put about the alleged coordinator of the alleged hit. That's Fisoguhle Ntuli, also known as accused number 5. Take a look.
The other thing, my lord, is that what they arrested me for is something that I do not know. Even mentioned the accused 3, accused 4, and accused 5. I do not know them. I know accused 5 by seeing him, but we are not acquaintances.
I went to Carltonville on the 18th, my lord.
Yeah.
I then come back to accused number 5, my lord. I repeat, my lord, we are boys back home. We were born or grew up or raised in the villages. Maybe there is confusion between the two languages, English and isiZulu, my lord.
My
lord, when I got to Boksburg, Mube greeted me, asked me where I'm from, and I told him my home, where I'm coming from.
Now, as always, we have guests to help us better understand what we heard in court this week. In studio, I'm joined by commentators Bongani Masugu as well as Itumu, who bring the voice of ordinary South Africans who are interested in the matter and follow it religiously, but also to give us the legal background. We're also joined by Mpumelelo Zigalala as well as Abigail Ngobeni. Those are our legal analysts to sort of help us better understand the legal intricacies in this particular matter. But you would know that Bongani Masugu is part of the voices that believe that these are the wrong guys. But we have a lady in the room who's joining us in studio for the first time. She joined us last week, Itumu. Thank you very much for your time. I'll start with you, Bongani. Let's talk about, the challenge on Bongani Ntanzi's relationship or whether or not he knows accused number 5. A version previously put, do you believe he's caught in a lie or he gets an opportunity really to fix what was previously put?
The evidence you're talking about, ne, to say he knows him or not, depends on what? Cell phone record, right? So I can't speak about that, except I want to go back to that cell phone record, because there's more to say about this cell phone record, because the relationship is allegedly proven through a cell phone. So I have a problem with the cell phone. I wonder if you want to give me time to explain my problems with the cell phone.
We'll come back to your explanation. Itu, what do you think of Bongani Ntanzi? Is he simply caught in a lie here, or, you know, he gets a better opportunity to explain?
He is caught in the biggest lies, not just one lie, Mnisi. He's caught in multiple lies, and his explanation is also quite worrisome. I'm very interested to hear how my friend over here is going to cook this week, because what we saw this last week in terms of Ntanzi and his evidence, and knowing accused number 5 or not knowing accused number 5, I mean, Baloyi has put it on the table. You guys have a common contact. You guys have been talking multiple times. How do you not know? Ntanzi also says that I once saw Ngimazela from seeing him. Okay, I don't personally know him, but I'm Ngimazela from seeing him. But then when they interrogate the seeing him, he shies away. So Ntanzi is caught in multiple lies.
It's also like the issue around whether or not he ever, Bongani, went to Phosphorus, or whether he knows Phosphorus. There seems to be an issue there, because the state now going back to bank records to say, hey, you seem to have made a purchase at the Naledi Mall, which is very close to where accused number 1 says he stayed at the time. What is your assessment of that?
First of all, that was triggered by Constable Zungu. We will come back to the issue of cell phone, of Capitec Bank. I think it's Capitec Bank, if I'm not mistaken. We'll come back to the bank records, because from what I know is that they are considering getting an expert so far as that is concerned. But when you're looking at the fact that Ntanzi was brought together by Constable Zungu, there are things when it comes to Constable Zungu that are like, Constable Zungu, you are the only state witness whose version was never collaborated anyway.
But that's not true. We know that's not true.
Why are you saying it's true?
Because we know that there's multiple people that came to testify. For example, there are cell phone records, Pinky Vitalingham saying that the tower pinged. The phone of accused number 3 pinged at a tower that is at the hostel. So it cannot be true.
You took me back to the cell phone. I was, Nisi, I'm going to take you chronologically.
Yeah.
But for me to make it make sense to you and make you understand, Ntanzi, also Ntanzi, when I got arrested, it was on the 16th of June 2020, right? When I got arrested, my cell phones were confiscated by who? Police officers. Now, the pain language straight. Oh, there's a man who testified to Article Committee. He is a former acting national commissioner, Mr. Khumalo Paslan. Who to Khumalo Paslan? Guys, when we police officers arrest you, we don't even ask you this. We confiscate even the belt, all kogil. Now, on Mauzo Vela Onuti, Ntanzi's cell phone, in the following Mnisi. Hi, Ntanzi was arrested 16 June. His phones confirmed by Awom Juan that were taken by the police. So why ask Ntanzi about his cell phone record when Ntanzi himself says, no, I'm a phone number, I'm a police, right? I'm a police on record, are confirming. So why talk to me about my phone? So I'm saying when Paslan said that, the penny shine up and says, when you're
but the ad hoc committee is not inside the court, so whatever happens outside the court does not necessarily directly affect the proceedings. I'll come back to you. Let's go to our legal analyst. Mpumelelo Zikalala, thank you very much for your time. I'll start with you. The issue of versions, the state putting a version that was previously put by a defense lawyer, now seemingly in conflict with what the witness is saying. Let's talk about that.
Greetings to you and also to the fellow panelists and my learned colleague. Remember that what the state is trying to do is to say, you are contradicting yourself and you're not being a credible witness. Look at how you respond in two versions which are identical, exactly the same. It's just that they've been put by different side of the spectrum. But in this case, you're answering in a manner in which you did not answer to in the previous version. Remember, how do we test consistency? No matter how I pose the question to you, the answer is always going to be the same. Then I know that you are being consistent and you are telling the truth. If you differ from it, then tell me the reason why. And if you do, then I'm going to latch on the version to say you're not being truthful in the manner in which you are answering. We cannot trust your version of events. Now, let's move on to the second part. Remember what the state is trying to do here is they are relying on what we call the doctrine of common purpose. You knew each other. You communicated with each other way before. You have planned this process and this thing to the T, and this is how you've executed it. There are various players that are there, and look at what has taken place. These are the results. So we want to put you under one band and make sure that you are able to punish you in the same spectrum. So all the questions which are going to be asked by the state are going to drive towards those two very, very important points. And up until now, I don't think that the Ntanzi is being able to absolve himself from this whole process and the web of what is happening within this trial.
Abigail, let me come to you, because ultimately it also boils down to the issue of credibility. Is Bongani Ntanzi a credible witness, looking at how he fields those questions and the versions that would have been placed before court previously?
Good afternoon to you, Linda. Good afternoon to the guests in the studio, and good afternoon to my learned friend who have just spoken, Mr. Zikalala. Yes, it is a difficult question to answer on these two grounds. It is for the court to assess the holistic evidence before it and the manner in which witnesses testified to determine the credibility of a particular witness. But to answer your question, I would say it seems to me that there are a series of events that if they are put to him, he falls short of answering satisfactorily. And I think to a certain extent, the judge did lament to that aspect. And of course, you would have noted that there is a comparison that is being done to show the modus operandi, or to show how he has been, the pattern of how he has been utilizing his device. And that accounts for before he was arrested and what the state is trying to put now after he was arrested. And some of the things for me, he has been failing to explain. And for that reason, I think the court is going to assess, like Mr. Zikalala said, the consistency. The court is also going to really focus on his demeanor as a witness, and the court will also be in a position to assess on whether or not he has been able to narrate events in a manner that is satisfactory, and on that basis, the court will find on the credibility of the witness.
Mpumelelo, is there something to be said about the fact that these cell phone records are largely not disputed, right? It is the explanation that comes, that now seems to, be a slightly a problem here. When you look at the fact that when they were first introduced, when they were given to the defense, and the attitude that was taken around them, those records or those transactions are not disputed. And I wonder if there's any way to be placed on the fact that they're not disputed.
And in fact, that helps the state, because if they're not disputed, that means explain the transactions which are going to be there. If you're going to dispute the transactions which are taking place, then it is the defense that should have said, we want to call the service providers, necessary service providers, and say to them, were these recorded accurately? Who extracted these records? Where were they stored? Is there any manipulation that would have taken place? So to come at this late stage and say that, well, the phones are not with me, they were with somebody else, and they are looking at a transaction that happened years ago, it might cause a bit of a problem if you're not going to come with credible evidence that says, I'm going to call a person from this network service provider who's going to say and tell this court that indeed they were manipulated, or there were instances in which we did not have control who was typing or who was editing those records as they are. So the only defense or any mechanism that you could have in order to defend yourself in this case is to say, let me explain what those transactions are about. To simply say the phone was not with me at the time, unfortunately, it's not going to suffice.
All right, so hang 10 because I want us to take a quick ad break. When we come back, we'll still talk about the cell phone evidence because I see Bongani Masuku here in studio is itching to respond to the legal analyst. So we'll continue this conversation after this. Welcome back and thank you for choosing to stay with us. If you've just joined us, this is Inside the Courtroom, the Senzo Meyiwa murder trial wrap, where we reflect on the past week's evidence in this matter. Now, one of the big talking points has been Ntokozo Mjiako. This is the lawyer that allegedly represented Bongani Ntanzi when he allegedly made his second confession statement before a magistrate. It's Ntanzi's version that he never gave Mjiako a mandate to represent him. Now, cell phone records traversed by the state this week revealed that the please call me messages are sent to Ntokozo Mjiako's number, but also their calls. Take a look.
So the point that was trying to make was that, can you see that the number belonging to Mr. Mjiako made contact with the number that belongs to you on the day of, on the day of your appearance at the Boksburg Magistrate Court, 27th of October 2020, and also a day after your appearance on the 28th of October 2020, as well as the other previous occasions that we have put on record. Do you have any comment?
I did mention it before the court that I had no phone. As to what was happening with my phone, wherever my phone was, I know nothing about that.
Okay.
All right, so the state also went through call records of Ntanzi's relatives.
It's the number 079 0696750 saved as Mama Wami.
Yes, I see it.
Whose number is that?
Although it's been a while that I've last seen the number, but it appears, it looks like Mom's number.
Then going back to Exhibit DD5E, Roman figure 1, on page 2, the very first PCM there, your number 06090168890 on 1 September 2020 at 17:39:43 sends a PCM to the number safe as Mama Wami 07906966750. Then your number 06090168890 on 10 September 2020 at 17:18:59 sends the number of sends a PCM to the number safe as Mama Wami 07906966750. Then your number 060 901 6890 on 10 September 2020 at 18:25:43 sends a PCM to the number saved as Mama Wami 0790 696-750. Then on page 3, your number 06090168890 on 10 October 2020, 1829:53. Your number sends a PCM to the number that you say belongs to your mother, 07906967750.
All right, remember we asked you to get in touch with us on WhatsApp as well as on our social media platforms. Let's check in with your WhatsApp messages now. We have a message from Mandlenkosi Nkomo who says, remember, no one gets arrested and left with his cell phones and left with him for more than a month. Where was it charged? Because any gadget would not last a week uncharged. That's our first WhatsApp message. The next one from Mxolisi Mngoma, who says, good day. The state didn't have a case against the 5 accused who are in court. No evidence has been presented so far. Just hearsay from Constable Zungu and the state prosecutor. Itu, let me come to you. Let me come back to studio to my guest, and I'll go to you, Itu. You know, the issue around Ntokozo Mjiyako,
Yes.
the disputed lawyer. Now we are going through cell phone records, which in the past segment we discussed were not disputed. Ntokozo Mjiyako, again, there is a call, particularly on the day that Bongani Ntanzi made his first court appearance.
Before we get there, Linda, I just want to say to my friend here that over the festive season, the police seized over 8,000 cell phones in prison from inmates. So the idea that inmates don't have cell phones with them cannot be believed. When it comes to Mjiyako, which is Ntanzi's lawyer, I believe we owe him an apology because we've come full circle with Mjiyako. Firstly, he was the gentleman that walked into court with sunglasses that Ntanzi knew nothing about. But since the state has led their Section 205s, and we have now heard that on the day of the appearance, Ntanzi actually did speak to Mjiyako. So now the issue is, Ntanzi's only issue is who is paying him. That's his only problem. Who is paying him and who gave him a mandate. So it's not that I don't know him, I did not speak to him, I did not consult with him. That's no longer an issue. That's why I'm saying we owe Mjiyako an apology because clearly he had a mandate. And as Judge Rata and I believe Ramsipele concluded that if we want to see Mjiyako in court, and we have questions from Mjiyako or clarification questions from Mjiyako, there's only one person that can get Mjiyako into court, and that is Ntanzi. He has to waiver his rights, his attorney and client rights. That's the only way he can come in court. The court cannot interfere, the state cannot interfere. That is his right. So therefore, the mere fact that he has not been called or will be called, we don't know. Depends on what my friend over here is cooking. We don't know if he will be called, but should he be called, he will be called by Ntanzi.
Yeah, and what are your thoughts on Ntokozo Mjiyako? I mean, you did say you have a big problem with the cell phone records, but now we're hearing, of course, of a conversation with Ntokozo Mjiyako, at least communication, that lasted some minutes, which means there was a communication with the number belonging to Bongani Ntanzi. Do you still believe it was somebody else and not Bongani Ntanzi?
I told you guys, we are closing nice. I told you guys, we are cooking. I'll start here. I want to put things together for you. One, we'll start with Pashan. When a general tells you this is the procedure of the police South African Police Service, that's the point I was driving home. Whether he's testifying in ad hoc committee or Madlanga Commission, the bottom line is that it's under oath there. He's telling you about the procedure, yes, South African Police Service. You cannot dispute that. No one in the SAN in South Africa has disputed that. No, he's lying. That is never the case. Saying, when we arrest you, we take even the belt. It belongs to us. You'll get it, Maupum. Now, with that being said, My friend here says, look, there's a call, there were 8,000 cell phones that were found in prisoners. You know what? Wrap the conversation this way. You're looking at the number. They are saying this number was used by Ntanzi before getting arrested. You say, okay. So they are continuing with that line, right? So if you continue with that line, you will then have to make it make sense to me, because me, I'm a man born under sin subject to correction. You will have to tell me that when police arrested Ntanzi, took his phone and placed it SAP13, right? And the phones were in the storage of South African Police Service. Make it make sense to me. Do we have an OB that says, no, my phone Ntanzi were somehow stolen on a certain day, thus they were found Ntanzi, and Ntanzi then called people? If you're saying to me there was never a time where there's an entry where these phones were stolen from the SAPS storage, which will say SAP13. If you say to me there was never such a day and a time, there's no such an entry, then you are simply saying to me, police must come and testify. When you took Ntanzi's phone, what did you do with that phone? That's simple news.
We've already heard from the police officers who testified. I want to come to the legal analysts. I mean, this issue about this disputed lawyer is one that is very critical because it directly impacts the confession statement of Mpumelelo. And, you know, having heard the evidence around Ntokozo Mjiyako, at this particular point, would you say the state is clutching at straws or they've hit the nail on the coffin?
I would say they've hit the nail on the coffin because there is no dispute which is there, or even the calling of the attorney to come and testify. Now, if you call the attorney to come and testify, it must be separated into two ways. You are not calling him to say, come and account as to what did you discuss with your client. All I'm asking you to do is to confirm, are you a legal practitioner? Have you ever received instructions from these individuals? End it there. That's the end of your evidence. As to what instructions you were given, I'm not interested in that because I will now crossing the Rubicon into client and attorney privilege, which is not something that we should be doing. But nonetheless, remember that whenever allegations are made in any criminal case, you both get an opportunity, that's the state and the defense, to call any witness that you want to call. In fact, from the side of the defense, I get an opportunity to admit or deny certain evidence that is there so that you curtail the issues that are in dispute and you call witnesses which are going to be relevant. So if there's a dispute about cell phone evidence, don't accept it. Simply say, I'm not accepting this one, bring all the people that are involved in the chain of evidence, let's deal with it. If there's a dispute pertaining to the attorney or legal practitioner, you again state on record, I'm disputing this one, and you state all those, whether a pre-trial conference is taking place, yes or no. Even when you go along and you have been given information as to which is the next witness which is going to come about, you state that. The second part in which you then get an opportunity to state your client's case clearly is when a particular witness is on the stand. In this one, it would have been the investigating officer in which you then poke holes to what the IO is saying. Once they refer to cell phone evidence, you poke holes in that, say that our client is going to dispute there was even a cell phone within his possession, and you must go and account. In that way, you are giving a heads up to the state to say, I'm going to dispute whatever that you are stating within the cell phone evidence realm, so you must make sure that you bring evidence pertaining to that. If you then admit it, you can then, at the stage in which your client is at the stand, in which you state all these allegations in which you would have been given an opportunity to dispute, but you did not, and you admitted them, and you're only disputing the transactions which are taking place, which, by the way, is linked to who was handling the cell phone at the time. So I think that's where the dispute is going to be. But with the legal practitioner, there's still an opportunity to call him. In fact, he can call him himself and be able to exonerate himself 100%. But if they choose not to come and attend, then the version which has been stated by the state now seems to be more probable.
Yeah, Abigail, let me quickly come to you. Let's talk about, you know, this idea of calling Ntokozo Mjiyako. The state went to call a person from the Legal Practice Council, right? You know, Mpumelelo raises the issue of him coming and just confirming whether or not he had a mandate and whether or not he was the legal representative of the accused. Okay, they did not bring him. What are the risks associated with calling Ntokozo Mjiyako, if any, for Ntanzi?
Well, you remember that here the state bears the onus to prove beyond reasonable doubt that the accused before court are correct and they are linked to the offense. And as it relates to Mr. Mjiyako, It is for the state, of course, to discharge evidence to the extent that there is a linkage of the said attorney and the witness in the witness box now. And of course, the state have led evidence from the LPC talking to the fact that Mjiako is a practicing attorney or was a practicing attorney at the time, and the fact that there is some communication that was even initiated by Mr. Ntanzi to Mr. Mjiako. That, for me, from where I'm sitting, suffice for what the state have to prove. But of course, the defense, if they rebut or they dispute the relationship between the two, of course, now they will have to come and bring evidence before the court that rebuts that in its entirety. But where we are now, I cannot really say that it is risk on the state. I can only think from where I'm sitting that the risk of calling Mjiako can be more detrimental to the defense than it would be to the state, given what the state have already said, both in examination in chief, even before the close of the state's witness, the state's case, and now that they are putting the documents or the cell phone records on the accused person.
All right, I want us to take a quick ad break because when we come back, we'll explore other avenues when it comes to this cell phone evidence because there's quite a lot that has been touched on. So you don't want to miss that conversation, and stay tuned. Welcome back. Let's check in with our poll question. Remember, we do ask you to weigh in on the conversations that we asked you. So today, we asked you, what do you think of Bongani Ntanzi's evidence? Do you think it is on the right track? Do you think it lacks credibility, or you are simply not sure? So 23% of you so far have said that he is on the right track. 73% of you says he lacks credibility, and only 4% of you are still not sure. So continue voting on that QR code. We'll announce the results at a later stage. So we're running the question throughout the program. So you can just simply scan the QR code on your screen right now and make sure to cast your vote. Let's go to your WhatsApps now. Anonymous says, it is common knowledge that when you are arrested, all your belongings, including phones, are confiscated. Now you have Ntanzi's phone all over the province, but no one is telling us how possible that is when he was in custody. So that's a comment from Anonymous. Let's move on to our next WhatsApp message. Is from Innocent Mweli, all the way from Ebalvo, who says, good day, Linda. Ntanzi is trying his best to defend himself, and I like that. He's the only one for now who is still making me believe that he didn't kill Senzo. My concern is about those editable phone records, airtime purchases of 130, etc. Lastly, I noticed that the data on the gallery photos is editable. So to trust the state with the data of photos is risky. Let's move on to the next comment from Mike Molemahang, who says, hi, Linda. Ntanzi's evidence won't matter or make any difference due to the complexity of this case. Remember, we haven't heard about the second docket. Interesting that he raises the second docket because we're still dealing with 636. And I don't want to go into, how that docket what was, disclosed and what Brigadier Bongani Ntanzi has said, because we haven't heard from, other people. But I want us to continue here, because the state continued to traverse transactions performed on Ntanzi's phone in the months after his arrest. It challenged the assertion that Ntanzi was not in possession of his phone by looking at transactions performed in 2018 being similar to those performed when he was in custody. Let's take a look.
What is your comment? On these dates that we've just put to you, you use the same features as the features that you use in 2018, November 2018.
I am not from Vodacom. I do not know what this means. That which is written here, I don't know what it means. The only thing that I said, which I answered here, is that when you are doing this, this is what this is what you'd be doing, or this is what it means to be doing this, which I explained. Just like here, there is star 111 *082 hash. I don't know what that means.
Given the information that we have traversed from yesterday, indicating that airtime was purchased, are you prepared to accept that the were recharges to your number?
No, my lord.
Why not?
The reason being, my lord, where I was, I had no phone, so I don't know what was happening where the phone was. And when the phone was taken from me, my lord, it was not switched off.
All right, so Bongani Ntanzi, they're adamant that he did not have his cell phone. Itu, let me come back to you. I mean, what do you make of the pattern that the state seems to be painting here, that you say you bought this number or this phone, or you started using this number in 2018. There are transactions that you performed at the time, which are quite similar to transactions that we see in 2020 when you were in custody. But also, you'd recall, they also drew a pattern. Not only was there communication with Mjiako, there were also communication with other relatives. Surely, if there was communication by anybody else other than Ntanzi, he would have other witnesses that would come and say, I got a call from Bongani who said this to me.
Oh, absolutely, Linda. What Ntanzi is currently doing is increasing his witness list, right? Now we need to hear from Capitec, because according to the Section 205s, Ntanzi was actually purchasing airtime before he went to jail. That's 2018. The same way he was purchasing airtime in 2020. So the patterns are still the same. And now we have the same cell phone calling his family members. If I was Ntanzi, I would call my family members to say, hey, I did actually receive a call, or I did make a call, because some of the calls, nothing happens. There's no please call me. It's just a random call coming in. And the tower that it's hitting, it's the same tower that Ntanzi is being housed, so in prison. So if the police had Ntanzi's phone, that means I would be on the field investigating a case. I would have to know that Umama Ntanzi is going to call me so that I can connect to the same tower. It does not make logic sense. It does not make sense for one to time it so perfectly, be in the same facility at the same time without asking anybody to call them. That is big issues that Ntanzi is going to have to answer, or bring witnesses to explain what were you guys talking about. Mulabuheng, 1,718 calls between this phone and you, my girlfriend. Who were you talking to on these phones? And what were you guys talking about?
Yeah. What is your response to that, Bongani?
You know what? She's saying whatever she said. I'm thinking to myself, wait a minute. So you mean you're going to call the police and say, guys, SAP 13, eh? You mean you're going to call them and say, hey, guys, we lost this phone, go SAP 13. Is that where you're going? Because your problem with this thing is that if you first agree that you took Ntanzi's phone when you arrested him, then you'll have to say, when you took the phone, is there an OB entry that says Ntanzi lost his phone, or we lost Ntanzi's phone in the SAP storage? If you cannot say that, Then the police then themselves, they will have to come and explain, good, le phone le, iphume kanjani, ifike kanjani kuNtanzi when they took it the day they arrested him. That's the problem. That's what we are running into right now. But another interesting thing that you are not saying is that, oh, Ntanzi is being arrested, housed in different police station, right? The phone, that's a problem that you are running into. That this house, this police station, that police station, that police station, it only beeped on specific occasion. But what makes matters worse is that you will remember under cross-examination, I think the advocate was Advocate Baloyi, cross-examining Mkhwana. Mkhwana is being asked, on this date, Ntanzi was being questioned by Brigadier Keninda. And Mkhwana agrees and says yes. And then Advocate Baloyi says, tell us then, the cell phone is beeping. Why is this cell phone picked up? I think it was somewhere around 4 hours. Why is this cell phone being picked up here? Do you remember the answer from Mkhwana, what he said? You forget. Now, let me remind you, my friend. What happened is that what Mkhwana, no, we took Ntanzi's phone on the day to where? Hickleback. That is where the guys, SAPS, download my phone. That is where they were downloading those phones. Oh, you forget. Don't worry, I'm here to remind you.
So the question here is, if it was not Bongani Ntanzi, then surely it was somebody else.
That's what the SAPS must answer us.
The state has run its case. Let's talk about, what this would mean, Bongani, for Bongani Ntanzi, because ultimately it says it's not him. So who else could have spoken to his mother? Who else could have spoken to his relatives? And
thank you.
Yeah.
Thank you. The same way Mabena took Ntanzi's phone and said, I only has a petin. And then Ntanzi gave him a petin. And then Mabena, you took a phone number, Uban, I think Umbata. The same way Melebas Tazel Guti, Mabatata that petin, what did they do? Why did Ifon Ntanzi called Mabena twice? The same way they are not explaining that. The same when Advocate Baloyi was asked that question, you know what Advocate did? Advocate Baloyi went and says, but my phone called Mabena here. I mean, I never had phone number of Mabena. What Advocate Baloyi was like, hey, my lord, okay, I'm not going to answer that question. Jambela in something else. So the complexity of the matter is this, that when you look at this, Ntanzi is simply saying, guys, my phone were taken by the South African police members who arrested me. What happened after that, I don't know. Ntanzi's defense is consistent. That's why he's running away from answering. Oh, he's not necessarily running away, but he's saying, I don't want to answer Uguti, who did I call? Because my phone was not with me.
Yeah. Let me come to you, Mpumelelo. I mean, we are hearing of, patterns, right? Obviously, the allegation would be it's the cops. If, I wasn't in possession of my phone, the cops would be in possession of my phone. Bongani raises the issue of the pattern. This phone is a phone that had a pattern, so the cops would have had to know the pattern. These cops would have had to, know details of his banking records. Let's talk about, the complexity of purchases of airtime and what it means, to his defense that I did not have my phone. Do you think at this particular point, at least, there is a level of support for what he's saying?
You see that assertion made at this point in time in which he is making the evidence, it has very little weight that can be attached to it. If it was made earlier, at the start in which the state was providing, firstly introducing the cell phone evidence would have been much better. There are two things which are looked at whenever evidence is being assessed. One, admissibility, and the second one, probability. With admissibility, how was it obtained? Who was there? Was it tampered with? So if you dispute that, you are then saying to the state, I want you to call the network service providers, call the people that handled the chain from the first instance where it was obtained up until now. If there are disputes about transactions which are taking place elsewhere and the phone was confiscated from him, that is when that evidence is going to be raised to say, but wait a minute, it's inside the SAP 13 and I'm outside or in jail. How did it happen that this cell phone, well, there was transactions which were taking place? Show me that there was no tampering that took place. even in instances where it is taken for downloading. Even call the person who handled the download to say to them, how did you do it? Was it in line with the normal procedures? You want to protect whether it is authentic or not. This is admissibility. We then move on to the second part. How probable are these transactions pertaining, if we look at the person who we are alleging that transacted within them? Well, let's look at their previous patterns. How do they buy airtime? Do they buy airtime for 30 rands or probably for 160 or even more? How long does that airtime stays and how is it utilized? Check those two instances before arrest and after the arrest. And if it's more or less similar, the probability that the person who's using the cell phone second time wise is probably the same individual are probably more. Again, you still have an opportunity to dispute that. How? Attack the admissibility, attack the probability, and then state those instances in which you are no longer in possession of the cell phone. Even go a step further and say, you were saying that you called my mother. Let's call my mother to go into the witness stand. She will be able to testify that she has never received a call by me. All that she knew is that I was in prison. But if you're not going to engage in those things and provide that evidence, then you might have a problem. Remember, when you go to court, it's a blank stage for both the defense and the state. You must place that evidence. Do not assume that the evidence is going to be placed for you, or that the doctrine of saying that you are innocent until proven guilty is going to play a larger role. Yes, it is there, but you still have to answer and provide valuable explanation.
Abigail, let's quickly come to you. I mean, Mpumelelo raises the issue of bringing witnesses that would help corroborate and challenge this particular aspect. Would, it be wise for him to call his mother, his relatives, who will then support his version? But also there'll be the question of, why is this information only coming out now? Because we've dealt with the issue of the cell phone, and you've previously denied that you had a cell phone in your possession. So why are we only learning now that your mother never communicated with you, but communicated with a police officer?
I think in your question, Linda, there's also an answer. And I'm saying that because in the trial proceedings in criminal matters, the proceedings must be fair to the accused as much as they are fair to the side of the state. There's something called trial by ambush. You cannot, without having put the version of these witnesses when the state's case was still open, come in a later stage and come to and adduce evidence of a witness that whose statement was never disclosed or who was unknown from the beginning that the witness will be called. So it will be very difficult for Mr. Ntanzi to come up with any person that is new whose evidence was not known at this late stage of the proceedings. So I really do not really think from where I'm sitting that there is a room for him to call his mother unless if the court comes to a conclusion that it will be fair for that witness to be called, which I do not think it is likely to happen.
All right, so let's take another quick ad break. When we return, we wrap up the show with more viewer comments, of course, as well as the poll question that we're running for you. So stay tuned. Welcome back and thank you for choosing to stay with us. Let's check in with your viewer comments right now. Remember, we said you can make contact with us on WhatsApp, and we have Samuel Mojano who says, good day. What is more surprising is how one could use a cell phone while in prison, unless they wanted to tell us that the prison warders were involved. So that is Samuel Mohane, who's weighing in on this particular conversation. We also have Sello Mulapis, who says, not enough criminals are in that court. People who know the truth are not in court. So perhaps referencing to other people who he believes should come and testify in court, or should at least be, charged for the murder of Senzo Meyiwa. Seima Mashudu Victor from Tembisa and Kopanong says, good afternoon, Newsroom crew. This case is going nowhere. It's just wasting state's money. Call Kelly Khumalo, her mother, Chico's son, and whoever else. So it seems there is a greater interest to call those who were inside the house. But in this segment, I want to start with our legal analyst, because at this particular point, it seems the state's cross-examination is really dealing with elements of cell phone record to further challenge Bongani Ntanzi's, assertions that it couldn't have been him who communicated with his family, and largely also his credibility in Mpumelelo. And I want us to, in fact, zone in on the issue around, if he had his cell phone from the first instance, then what the state is trying to tell the court, that even the complaint about him having not bathed, not communicated with his family, really could really just be improbable.
Definitely, and that's one aspect in which they will try to prove. But the second one, which I view as being important, is the one that there's constant communication with the legal practitioner. The legal practitioner knew that there was a confession which was being made, and if that confession was made, then he would have complained to him sooner than later. So let's admit the admission statement that you have made. Remember, here you have a document that says, yes, I did it, which is on record. And the only way in which you can be able to suffice from that, if you provide evidence that proves otherwise, in which up until now, evidence pertaining to that has been very little. The other one is to say, well, you didn't have a cell phone inside and you're communicating with all the other individuals which are there, including your parents. So if there was a cause for concern, we were not treating you well, all of that could have been there, which leads to one thing. You are not forced or coerced in any manner in order for you to write the statements, then it must be believable. How are we going to do that? Let's look at the probability, circumstances and the way in which you acted before, circumstances and probability and the way in which you've acted after. Then there's the only conclusion that you can draw down to is that it is you that was using the cell phone. We may not be able to prove how you got your hands into the cell phone, but at the end of the day, it has been admitted as being evidence, it has been admitted as being authentic and true by your team. Hence, let's look at the actions that follow and interrogate whether those actions are in line with the manner in which you acted. And if they are, you are the one that wrote that confession statement, and we want to hold you to it, and you must be convicted based on such.
Yeah, and Abigail, I mean, the confession statement is something that really is big, right? Because, he's been trying to fight it, to have it thrown out of court. At this particular point, what can Bongani Ntanzi do to ensure that that confession statement or those confession statements are thrown out of court?
It will be very difficult, Linda, to come to that conclusion where the confession statement is thrown out. I'm saying that particularly because of the kind of evidence that has already been adduced and what he's been confronted with now. The fact that he knows, the state is trying to prove that he knows Mjiako. He knows as well the number of Mjiako. There has been a communication there. Him denying the fact that he doesn't know Mjiako will necessitate or will require him to bring more evidence before the court to justify that narrative. And it's his responsibility, of course, to come and rebut the state's case in its entirety, including that particular confession statement. But one other aspect that I want to raise, Linda, which we should all be alive to, is the fact that conviction of the accused person will not solely be in one aspect of the trial proceedings, or rather the evidence. The court is going to look at the evidence in its entirety. And then the issues of cell phone record is just part of the puzzle, which the court, when it's viewed, will have to look at it and determine if there is any reasonable inference that can be drawn to say there is a communication or these particular transactions are known to the accused person. So it is very difficult for me to come to a conclusion that he will be able to have that confession statement thrown out of court, given the fact that he has not provided the court with any, if any, substantial or enough explanation to the effect that that statement was not made by him and it is not voluntary.
Yeah, let's come to studio. Bongani, let's talk about, what you think is the legal strategy here, right? Obviously, you believe that Bongani Ntanzi is cooking, is still on the right track. When you look at holistically where the defense is going in terms of rebutting the state's evidence, what do you think are things that we need to look out for?
One, look, Bongani Ntanzi is saying, guys, when we were in Boksburg, we told this advocate that, hey, we shall shy you lapa. He must come and answer what did he do. We know he did nothing. Okay, we leave that. Two, you are saying Ntanzi bought airtime using these banks, the star 180 what in 2018. That thing was introduced in 2022, not 18. So I wonder where did you get that? I'm interested in that as well. Because when I checked NAMI, it told me about 2022, not 2018.
It told you.
Look, when you check when was it introduced, it's the same argument.
What do you mean introduced?
Angiti, it's the same argument that we once heard about WhatsApp calling. We know that that fixture was introduced, I forgot which year, but it was said to be introduced earlier than that. It's the same thing. There's something that is said Ntanzi he used, I think, around 2018. I think it's star 130, star 379, something like that. That thing was introduced somewhere around 2022. So I want to say to you that we are cruising nicely.
Are they cruising nicely?
Cook, Bongani, cook. I'm afraid it's getting overcooked here, right? Now we are saying things were created in 2020. I think Baloyi has demonstrated very well that we have a very unreliable witness who, when is confronted with his Section 205s, that they admitted those Section 205s with no fault, but now they want to go back. When confronted with those, he's blaming other people. He's increasing his witness list. We need Capitec to come, we need Vodacom to come, we need Mama Ntanzi to come, we need Mama Ntanzi to come. Everybody must come at this point because of Ntanzi. So I do not think this is a reliable witness. I don't think Judge Rata is going to have a tough decision at all.
All right, so I don't know if we still have any more viewer questions to go through. Okay, I'm told we don't have any, but let's check in with the results of our poll question that we are running for you. Remember, we asked you to vote and scan that QR code. So 71% of you says he lacks credibility, so seemingly not really having confidence in Bongani's evidence. So you would have seen we ran that, in fact, poll question throughout the program, and these are the final results. Let me thank my guests in studio as well as our legal analysts who are joining us via our Zoom link. That's where we leave it at for today. Bongani Ntanzi is back again on the stand on Monday to continue facing tough questions. You and I will see each other again next week to catch up on the upcoming week's evidence. Until then, have a good one.